The Supreme Court is filled to its capacity with lawyers as the court entertains an ex parte motion filed by 3 states, namely Kaduna, Kogi, and Zamfara states. The states are challenging the February 10 deadline of the Central Bank of Nigeria, when the old 200 naira, 500 naira, and 1,000 naira notes are expected to lose their status as legal tender. They maintain that the 10-day extension by the federal government is still insufficient to address the challenges trailing the policy. Moving the application, counsel for the applicants, Mr. Abdul Hakim Mustafa, urged the Apex Court to grant the application in the interest of justice and the well-being of Nigeria. Mr. Mustafa held that over 60% of Nigerians who do not have bank accounts do not have access to cash, and the number of citizens who do have accounts cannot access those accounts, as most of the banks have closed operations because of the policy. In its ruling, the Apex Court held that after a careful consideration of the ex parte motion, the application was granted as prayed. It made an order of interim injunction restraining the federal government through the CBN or the commercial banks from suspending or ending on January 10, 2023, the time frame within which the now older version of the 200 naira, 500 naira, and 1,000 naira notes may no longer be legal tender. The Apex Court held that this would be in place pending the hearing and determination of the applicant's motion on notice for interlocutory injunction.
We invoked the powers of the Supreme Court to hear this application. The reason for it is that as well-intentioned as this policy of federal government of redesign is working hardship all over the country, as we can all see, banks are being harassed, Nigerians are suffering needlessly, especially the downtrodden. Those in the urban areas, they're having problems, but it's more excruciating at the rural area. So these 3 state governments, Kaduna, Zamfara, and Kogi, deem it fit for us to invoke the powers of Supreme Court to intervene.
The court, in its wisdom, decided that something must be done because of the urgency. But the court has rightly, in its own wisdom, directed that all processes must be there by 15th, that is Wednesday next week, for us to argue our various positions.
The court subsequently adjourned to February 15, 2023, for hearing of the substantive suit.